Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review, we're going to be looking at a privacy notice. So we're going to be looking at this entity today. I want to cover some insights that haven't been covered in the past. It looks like they sell games. I want to talk a bit about why it's important for me to understand products and services prior to any type of review that is conducted for a business. From a US perspective, privacy laws are looked at in lots of different categories to include on a federal level, on a state level, and on an industry level. In addition to that, some states have specific nuances when it comes to personal data. There's legislation that's been coming out related to artificial intelligence that implicates privacy. So understanding what's in scope from a product and services perspective is really important for reviews and drafting of these notices. I'm just going to scroll to the bottom because I didn't see the date that this was last updated, and that's really valuable information. So it's really important, particularly for the United States, to have a date that you last updated your notice, because it is a requirement in some states. Now, the nuance to sentence that I've just stated is, if you don't meet the threshold in those states, then it's not going to apply to you. But it's valuable for your consumers to know when your notice was last updated, because it should align with the practices that you have for your privacy program at that time. So we know that the United States is in scope. I've talked about how important geography is from a privacy perspective in this discussion from a federal level, state level, and industry level. I do have a comment to make about games particularly. What is traditionally considered a personal data identifier like name can become more complex when it comes to games, because the technology is very sophisticated with games in 2026 and has been for a while, in that there's a lot of behavioral data that can be obtained related to how players engage with certain types of games. Now, I'm not terribly familiar with the games of this organization, and one thing that I think is very valuable for businesses to understand is privacy attorneys generally have a good understanding of the technologies and the implications from a privacy perspective. There's a term in the data protection space known as privacy by design, and particularly for organizations that are creating brand new games, not for those that are pre-existing, but essentially that term means whenever you're creating a product, have data protection obligations in mind prior to the creation, because it could impact the manner in which the games are played and the manner in which the personal data can be processed in certain geographies. Now, behavioral data could include things like these games generally can look at the behavioral patterns of the games played by different users. Let's say, for example, I am Funmi Owolabi 1 on game 2.0. On game 2.0, as I start clicking on the game and interacting with it, there is insights on the behaviors that I exhibit in that game that can be collected by organizations. Now, I'm not saying that's the case here. I think it's valuable to note that those clicks and likes and game moves can all be collected. And if they're able to be attributed to me playing, then they constitute personal data, because personal data identifies an individual. If an organization can understand how I, Funmi, click a particular button in a game and associate it with my name, it becomes personal data. And it has to be managed by organizations depending on the level of sophistication of the behavioral data that's being collected. I also think it's valuable for this particular notice for you to see that they've made several translations of their notice, anticipating that there are going to be users associated with this notice that may need to read it in other geographies. This gives me an inclination that this game is being offered globally and not just in one geography, even though the notice discusses United States residents. The other reason, and I'm going to clarify why I think it's so important to identify the date it was last updated. In the United States, at least in 2026, there has been the rollout of 3 additional US state privacy laws, bringing the total number up to 23 at this stage. So if you don't have a date, if your notice was drafted in 2018, at that time, or let's just say in 2020, there were fewer privacy legislations on a US perspective than there are now in 2026. So your obligations and the transparent language that you put in your notice is going to have changed. Let's actually click it. In addition to these terms, certain US state laws, now this has changed immensely since 2020. As of the recording of this video, there are 23 states with their own privacy legislation. So you can imagine that's changed drastically since 2018, 2019, and 2020. If you are a US resident, please click further info for more details that may apply to you. So we can see here that they've referenced the CCPA, but this is not the only state in the United States that has a state-specific privacy legislation. A lot of times consumers will see the CCPA referenced because it was the first privacy legislation on a state basis. And then in addition to this, at this point, it has the most restrictions of all of the US state privacy laws with respect to what a business must do in order to adhere to this legislation, which is why you'll often see this one referenced in many different privacy notices. So we can see here that that's the only one that has been referenced, even though there are over 23. So as a consumer, personally, I don't live in California. So my question is, has this notice taken into consideration the data protection laws that apply to residents outside of California, because it's not currently mentioned here? So that's another really important reason why the date is really useful. So outside of that, I think let's talk about this. I haven't talked much about the data protection laws associated with children's privacy rights. In the United States in 2025, there was an update to how federal privacy regulates children's personal data. And this goes back to my comment about reviewing the data protection laws on a periodic basis to ensure that your business is accommodating to the obligations that are being placed on you based on legislation. And then also making sure that you've taken into consideration you're putting in language that accommodates not just the games that you offer to children, but also the notice that must be provided on your website and in the geographies where children's data is being processed, because we can see here they've translated their privacy notice into lots of different geographies. Outside of the United States, there's going to be privacy laws that dictate how children's data can be processed in other geographies, and that has to be taken into consideration by a business. So I really hope you enjoyed this particular review. If you have any comments about what I've discussed, leave a comment below and I'll see you in another review.